I'm very excited to be your host and facilitator for the webinar on 3 new criminal laws. A very warm welcome to our invited speakers, participants, directors, heads of schools, divisions, units of IGNOU, regional directors, officials, faculty members, academic students, staff members, and my colleagues for joining this webinar on 3 new criminal laws. The purpose of this webinar is to create awareness among masses on the salient features of the new criminal laws, namely Bharatiya Nyaya Sanhita 2023, Bharatiya Nagrik Suraksha Sanhita 2023, and Bharatiya Sakshi Adhinam 2023. As a part of promotional activity to disseminate the information on new criminal laws, the School of Law has also distributed e-flyers on the respective criminal laws. The school has also prepared promotional videos and have organized various teleconferencing and interactive radio sessions. These new acts have replaced the old era criminal laws, Indian Penal Code 1860, Criminal Procedure Code 1973, and Indian Evidence Act 1872, respectively. The new act, the 3 new criminal acts are coming into force from today, the 1st July 2024. To provide the insight into these new acts, we have with us Dr. Shruti Goyal, Associate Professor, Rajiv Gandhi National Law University, Patiala, Punjab. She will take session on Bharatiya Nyaya Sanhita 2023 and Bharatiya Nagrik Suraksha Sanhita 2023. The another speaker on the subject is Dr. Jubair Ahmed. He is Associate Director, Research and Development Cell, Guru Gobind Singh Indraprastha University, and Assistant Professor, University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Delhi. He will give an overview of Bharatiya Sakshi Adhinam 2023. After each session, we will have an interactive session. So you are requested to feel free to use your chat box, share your thoughts, and connect with our invited speakers and fellow participants. With this, I look forward to gain insight into the provisions of new criminal laws along with all of you. Now I request Dr. Mansi to kindly introduce the first speaker.
A very good morning to all of you. Thank you for joining this session. Dr. Shruti Goyal is an associate professor in law at Rajiv Gandhi National University of Law, Patiala, Punjab. She has, a BA degree, a LM degree, and PhD in criminal law. She has work experience of more than 14 years of teaching criminal law to students of undergraduate and postgraduate level at national law universities. She has authored one book titled Bharatiya Nagrik Suraksha Sanhita 2023, Law and Practice. She has written more than 40 research papers and delivered more than 70 guest lectures to PhD scholars, PCS officers, research scholars, police officers, jail officials, and other officers working in the state administration. She has also contributed towards e-learning by making the e-modules for e-Pathshala, a project of the Ministry of Human Research and Development. She has been a member of District Legal Services Authority for the last 5 years, and she has also been registered as a member of Law Society of England and Wales. Her area of interest are criminal laws and forensic science. So, Dr. Shruti Goyal, I would like you to invite for this webinar.
Thank you, ma'am. Thank you for providing this opportunity to discuss with you the newly enacted laws that are coming into force from today. So I'll be giving you an overview of what changes have been introduced in the Bharatiya Nyaya Sanhit and Bharatiya Nagrik Suraksha Sanhit. Ma'am, can I share my slides?
Yes.
Yes. You can present.
Yeah. Just let me know. Can you see the slides?
Yes, ma'am, it's visible. You can make it slideshow.
Yeah, sure. Is it visible?
Yes.
Yeah, okay. So, first of all, let us see as ma'am has already told you that these laws will be coming into force from today. The bills enacting these laws, they were initially tabled in August last year, then they were withdrawn by the government, and then they were reintroduced in the month of December when they were passed by the parliament, received presidential assent in December itself, and today has been notified as the date for coming into force of these three acts. So first of all, I'll briefly discuss that what reasons are there for the change in these three acts, why we have repealed the old laws and brought these three new acts. As you can see, especially if we talk about the Indian Penal Code, it was more than a half and a century old. So, in this last 150 years, some new complexities have developed, some new forms of crimes which were not in existence at that time when IPC was drafted. So, in order to meet those situations, these IPC has been repealed and has been, now we have the Bharatiya Nyaya Sanhit 2023. So one reason is the complexities. For example, if you see offense like mob lynching, it was not very much prevalent at that time. Offenses like organized crimes, where we talk about mafia, they were there in some big cities like Bombay. If we talk about some years back when we were facing the problem of mafia, but we had some law in Bombay. We had Makoka, Maharashtra Control of Organized Crime Act for that very state. But then, as far as the pan India is concerned, we did not have any law for dealing with these organized gangs, which has become a menace in today's society. So, one reason is new complexities which has developed over the time. The second reason is the pendency of cases. As you see, in India, we have more than 5 crore cases pending in the courts. So it was thought that if we change the procedure to deal with these cases, criminal cases, maybe the disposal rate is high and the pendency is reduced. Another reason was the conviction rate. In India, we have 50 to 60% of conviction rate depending upon the offense. So the government wanted to attain a 90% conviction rate. In fact, in the speech that was given by Amit Shah while introducing these bills in the parliament, he said that we are making changes in criminal procedure code in order to ensure that we attain a 90% conviction rate from 55 to 60%, which we have right now. So this was another reason that was given for bringing new laws. In addition to that, we have the problem of delay in investigation. That is the new laws. They try to give us a frame period within which further investigation is to be completed. And then we had the problem of inadequate use of technology. Now this point is very, very important. See, in the last, if I talk about procedure, the Criminal Procedure Code was of 1973 and 50 years has passed since then. Now, in Criminal Procedure Code, there was no much usage of technology that was prescribed. And if we see in last 50 years, number of technological developments have been made. For instance, the things which have, come to our lives, which has entered our lives, mobile phones, audio, video, electronic means. So these kind of technology through which we can mention in CRPC at all. So one of the main reason and one of the major changes that has been made in criminal procedure is now we will see in last 50 years number of technology is now you'll see in the Bharatiya Nagrik Suraksha Sanhit, they are talking about use of technology at many places. In addition to these reasons, we had the problem of prisons overcrowding, and it was felt that we need a law which is citizen centric, which is oriented towards delivering justice to the poor. So the new laws, they aim at being accessible, convenient. There are a number of accountability measures that have been introduced and overnight oversight mechanisms which have been introduced. So these were some of the reasons why we have changes in the criminal laws. Now I'll specifically talk about what major changes have been introduced in the Bharatiya Nyaya Sanhit 2023, which has replaced the Indian Penal Code of 1860. If I talk about the number of sections, please see that we had 511 sections in Indian Penal Code, and now they have been reduced to 358 in BNS. The major change that has been made in Bharatiya Nyaya Sanhit is one, they have structurized the code. Indian Penal Code may we could see that the offenses they are scattered at a number of places. So one major change that has been made in the Bharatiya Nyaya Sanhit is that structurization has been done. For example, if we talk about offenses relating to women and children, it has been consolidated in chapter 5 of the BNS. So one major change is consolidation, that whatever provisions were there and they were scattered throughout different sections of IPC, they have been grouped together and put together in a chapter for more clarity. Similarly, if I talk about definitions, those who are from the law field, they must be knowing that most of the acts that we have today, section 2 of the acts, they talk about definitions. But if we see Indian Penal Code, there the sections of definitions, they were up to like around 70, 73 sections, the definitions were stretched. So what has been done in BNS is all the definitions that were there in Indian Penal Code, they have been put together in section 2 in the form of definitions. So one major change is the structurization, consolidation of different provisions that were scattered at places. Another change is some new offenses have been added, which I'll be specifically talking about in my next slide. The third change is for some offenses, punishment has been enhanced. As we can see, for the offense of gang rape, earlier death penalty was there for the offense of gang rape only if the victim was less than 16 years of age. But now that has been enhanced and death penalty is there even if the victim is above 16 but less than 18. So this is another change that for some offenses, the punishments have been enhanced. If I talk about punishment, one major change that has been brought in the BNS, Bharatiya Nyaya Sanhit, is a new form of punishment has been introduced in our criminal justice system, and this is the punishment of community service. Please see, this form of punishment, community service, it is in existence in other countries, USA, UK, you talk about other criminal justice system. There they are following this system of community service. As far as India is concerned, the courts, they were giving community service in certain cases, especially if we talk about the cases related to juveniles. They were giving this type of punishment, community service, but otherwise there was no statutory recognition to this form of punishment under Indian Penal Code. So one major change is, because I said one of the reasons why new laws were introduced was we wanted to deal with the problem of overcrowding of prisons. So, in order to reduce the number of prisoners, community service has been introduced as a form of punishment in which instead of sending the convicted person to the prison, he is asked to perform some community service. Now, community service has been introduced for 6 type of offenses. One is theft. Please see, theft, if it is a first time offender and the value of property is less than 5,000 rupees, then in those cases, the court, while convicting the accused, can ask him for community service. Defamation, offense of defamation, offense of stating suicide in front of public servant or anyone who is trying to perform his lawful duty, because this is a trend that is in existence nowadays. Many a times youngsters, they try to perform suicide, they try to state suicide in front of a government office just to pressurize them. So for this offense also community service has been introduced. Non-appearance in issuance of proclamation. If some person is not coming to the court when warrants have been issued and proclamation has been issued. Trading by public servant, and if some drunkard person is creating some ruckus in the public, then also community service can be imposed. So this is one major change that has been brought because a new form of punishment has been introduced in Bharatiya Nyaya Sanhit, which was not there in Indian Penal Code. Now, as far as this community service punishment is concerned, judicial magistrate first class and second class have been empowered that they can impose this punishment. But there are certain loopholes as far as community service is concerned because till now we do not have exact guidelines that what type of community service can be imposed, what a person can be asked to do, for how many hours, for how many days, and who will keep a look, check that whether he's performing that community service or not. So in order to make this punishment actually functional, will require rules that has to be notified by the government that what type of services would be included in the community service, and most importantly which agency will be responsible for overlooking whether the person is performing this type of service or not. So this is one change. Another change, as I told you, some new offenses have been added in BNS which were not there in Indian Penal Code. Now, if you see these offenses, they are prevalent. Snatching, which is very much prevalent if you see snatching of chains, snatching of mobile phone. So snatching as a separate offense was not there in Indian Penal Code, and a person could be charged only with the offense of theft. Now they have specifically given in the BNS that if there is a snatching, then it is a separate offense. Another offense that has been added is Terrorist Act. Now, again, Indian Penal Code did not have any provision to deal with Terrorist Act as such. We had special laws, but there was no general law which talked about terrorist activity and punishing Terrorist Act. So that has been added in Bharatiya Nyaya Sanhit. Organized crime, as I told you, nowadays this mafia or organized gangs or syndicates, by whatever name called, it has become a common thing, not only in cities like Bombay or states like UP, but even in other states and cities. So organized crime has been introduced as a separate offense in BNS. And if any person is a member of organized syndicate, even that is penalized under the Bharatiya Nyaya Sanhit. In addition to organized crime, they have also introduced the concept of petty organized crime. If we see, there are small, sometimes college going groups of 3-4 boys who are together, and they perform tasks like snatching, they perform things like question paper selling, small organized small crimes. So petty organized crime has been enacted as an offense. Another offense which was the need was sexual intercourse by employing deceitful means. Now we see there are number of incidents where the sexual intercourse, because there is consent by both parties, and the consent is given by the female because she is under the impression that the boy will marry her, whereas the boy does not have any intention of marrying. So this has been criminalized as a separate offense because it does not amount to rape. There has been consent by both the parties, but the consent was given by the female because she was under the impression that she would be married. So if someone commits sexual intercourse in those situations, that has been penalized as a separate offense. And here, even if some person by giving the lurement that you will be promoted, you will be given a job. If he does some sexual intercourse, then it is penalized under this very section. Another offense that has been added is mob lynching. As you know, nowadays there are many incidents of mob lynching where on the grounds of religion, race, caste, there is mob lynching. So that has been specially enacted as an offense. So mob lynching mein the death is caused, Now, what special has been done in BNSS? Any person who is a member of that mob, which is actually involved in mob lynching, every person of that mob or group is to be penalized under this very section. Another section that has been introduced, which was there in Indian Penal Code also, but now they have segregated it into three parts. That is when death is caused by negligence. Now, under Indian Penal Code, whenever death was caused by negligence, it was punishable with punishment up to 2 years. But nowadays, what we see is sometimes there are hit and run cases. So in that, the government, the BNS, it had increased the punishment of imprisonment up to 10 years. But let me tell you, hit and run cases may, if you remember, there was a lot of hue and cry across the country in the month of January when the truck unions and other people who are there in the business of transport, they had undergone a strike because death by negligence के case में, hit and run cases में, the punishment that is given in BNS is imprisonment up to 10 years and fine. So the government at that time, in order to stop that strike, they had promised the people that this particular section, it will not come into force. So please remember that in hit and run cases, although the punishment that is given under BNS is imprisonment up to 10 years and fine, but for now, today, this part of the section is not coming into force as promised by the government earlier. In case there is a death by negligence, in other cases, imprisonment is there up to 5 years. And there is a lenient view as far as doctors are concerned, that if a doctor has caused death by negligence while performing some medical operation, then in that case, the punishment can be only up to 2 years. So death by negligence ke liye, earlier there was one section only and the punishment was imprisonment up to 2 years. Now they have, graded it up to 2 years in case of doctors, in other cases up to 5 years, and in cases of hit and run, it can be up to 10 years, which will not come into force today, hit and run case wala part. Another change that has been made in BNS is that as far as marital rape is concerned, the age has been increased. Now there was a judgment of Supreme Court Independent Thought versus Union of India 2017, where the Supreme Court had said that sexual intercourse by a husband with his wife, if she is less than 18, then it amounts to marital rape. Indian Penal Code mein, it could be rape only if the wife was less than 15. So 15 से 18 years तक की if the wife is there, as we know that in India there are some parts where child marriage is prevalent and the wife, she is less than 18. So Indian Penal Code said if the wife is above 50, then there is no rape. But Supreme Court in 2017 said if wife is above 15, less than 18, then it amounts to rape. Now, BNS has given statutory recognition to this point that yes, if the wife is less than 18 years of age, then it would amount to rape. However, if she is above 18, still there is forceful intercourse, then BNS is silent. They have not done any amendment as far as this part is concerned. Another, now there are some misses also which have been made in BNS, which are very much, they are visible. One is relating unnatural sex. There was section 377 in Indian Penal Code which had been declared unconstitutional by the Supreme Court in the Navteej Singh Johar's judgment. But what was allowed by the Supreme Court was that if two consenting adults they have any unnatural sex, then that is not penalized. Now, by totally removing that section from the from our criminal justice system means that even if there is forceful unnatural sex, then also there is no provision in the BNS to penalize it. Similarly, another miss that is there is regarding section 498A, cruelty by husband and his relatives. There were a number of reports before 2023 which said we need to relook into these provisions of cruelty by husband and his relatives, because these provisions are greatly misused by the wives. However, if we talk about BNS, they have not made any change in this provision, except that now section 498A of IPC, it has been divided into two parts in section 85 and 86. And the Supreme Court few days back has again said that the government should relook into this section, because this new law is coming into force. So we need to relook and put some safeguards as far as cruelty by husband and his relatives as an offense is concerned. Another major change is some offenses, they have been made gender neutral. Gender neutral in the sense, it can be in two senses. One is as far as criminal is concerned. Second is as far as victim is concerned. As far as criminal is concerned, earlier, disrobing a girl or a lady or a female was penalized as an offense if the disrobing was done by a man. Now, in new BNS, they have omitted these words man, and if anyone disrobes, removes clothes of a girl or a woman in the sense that she is naked, then that has been penalized as an offense, and there is no bifurcation whether the disrobing was done by a man or a woman. Similarly, voyeurism, where a lady, she is performing some act in a private place where she is not she is under the perception that nobody is looking at her. Maybe she's changing clothes, maybe she's feeding her baby, anything which she is doing in a private place, thinking that nobody is looking at her. But if some person is looking, then this is the offense of voyeurism. Earlier, voyeurism was penalized only if that peeping was done by a male. But now in BNS, it has been made gender neutral, and whoever peeps, whether a male or a female, they can be penalized for the offense of voyeurism. So as far as criminal is concerned, it has been made gender neutral, because there is no bifurcation whether the offense has been committed by a man or a woman. If I talk about the victim, then there are some offenses like procuration of a girl, which was earlier an offense. Now they have made it procuration of a child, whether male or female. So that has been penalized as an offense. So these are some of the major changes that have been made in BNS, Bharatiya Nyaya Sanhit. Due to paucity of time, I'll be now moving to BNSS, Bharatiya Nagrik Suraksha Sanhit, like what changes have been brought. If I talk about Bharatiya Nagrik Suraksha Sanhit, then please see all the provisions that were there in Criminal Procedure Code 1973, most of them have been retained as such. There has been no alteration in the order also. The only change that has been made is there were certain amendments that were brought after 1973 that were numbered as A, B, C, D. For example, section 41, A, B, C, D. So now they have numbered as 41, 42, 43, 44. Consecutive numbers have been given. Otherwise, the order of sections remain the same in CRPC. They have not done any regrouping or restructuring as far as BNSS is concerned. It is similar to what was there in CRPC. Only 14 sections have been deleted and 9 new sections have been added in the BNSS. Otherwise, all other things, as I told you, are the change. Although 177 changes have been introduced. Basically, like I told you, 9 new sections have been added. What are those sections? These are the new concepts that were not there in CRPC that they have added in BNSS. One is some new definitions like what is audio, video, electronic means, what is electronic communication. These definitions have been added. One major change that has been brought in criminal justice system is with regard to proclaimed offenders. Under CRPC, only few offenses were enlisted that if a person does not come to the court in answer to these offenses, then he can be declared as PU. BNSS has broadened the purview of the courts. It says if any offense is punishable with more than 10 years of punishment and the person does not appear in the court for trial, then he can be declared as proclaimed offender. And the second major change as far as proclaimed offender is concerned is we have introduced a new concept in BNSS, which is known as trial in absentia of proclaimed offenders. Now, because the person is not appearing in the court in answer to the summons that were issued, warrants that were issued, proclamation that was issued against him, so there was this, even the Delhi High Court in Sunil Tyagi's case, and earlier the Supreme Court in Hussain versus Union of India's case, they had suggested that in these cases, where the accused is not appearing in the court, in spite of all the efforts that has been made by the investigation agency, we should allow the trial to continue. The trial will be continued in absence of the accused. The reason for this is that at least the victim will feel satisfied that because the victim is not to be blamed, the accused is not coming to the court. So there was a recommendation by the court, Supreme Court, by the Delhi High Court, that we should introduce this concept of trial in absentia in India. Please see, our neighboring countries like Bangladesh, they had this provision of trial in absentia of proclaimed offenders, and we have for the first time introduced it in the form of section 356 in BNSS, where if a person is a proclaimed offender, is not appearing in the court, then trial in absentia can be conducted. So this is a totally new concept that has been introduced. Another major change that has been made is recording of search and seizure proceedings. Now please see, from today, wherever search is conducted by the investigating agency in order to collect evidence, then all the proceedings regarding search and the seizure, they'll be recorded by the investigating agency. The main reason why this has been added is, as I told you, CRPC did not talk much about using of technology. So nowadays, technology, especially if we talk about recording, that is easily available. And one of the major reasons why we have low conviction rate in India is many a times whatever evidence is collected through search and seizure proceedings, it loses its credibility in the court because of whatever loopholes are pointed out by the defense. So that more credibility is lent to this proceedings, Section 105 has been introduced in BNSS, which says mandatory recording of all search and seizure proceedings whenever the investigating agency is collecting these, is conducting search or doing seizure. So this is one new section that has been introduced. Another is Section 107, attachment, forfeiture and restoration of property. Please see, till now, if a person did not come to the court in answer to the proclamation, then only his movable property could be attached. Because we are talking about criminal justice system, his immovable property could not be attached because he is not coming to the court. So one new section has been introduced, Section 107, which allows the investigating agency to file an application before the court that this person is not appearing in the court and the property, it appears to be linked to crime. So this property should be attached and forfeited. So he can file an application. The investigating agency can file an application before the court, although the investigating officer, he'll have to take prior approval of the superintendent of police or commissioner of police before filing this application. But this is for the first time that provisions have been made for attachment of immovable property of a person who is not answering or who is not coming to the court. Another major change that has been introduced is Section 172, which talks about persons bound to conform to lawful directions of police. Now, this is one section which is being criticized also, because here powers have been given to the police in the sense that if they give any directions, any lawful direction, if it is given by a police officer, then persons who have been given that direction, they are bound to conform to those directions. And in case they do not conform, the police officers have the power to remove them from that area and even to detain them for some period. They can be detained in the police station also, although the maximum time during which they can be asked to wait in the police station is 24 hours, beyond which orders of the magistrate would be required. But this kind of power was not there in CRPC. This is for the first time that we are saying that if any lawful direction is given by the police, then those persons who are asked to follow those directions, they have to obey those directions. Otherwise, the police can forcefully remove you from that area and they can even detain you up to 24 hours. And because the main reason for the passage of this section was sometimes the situation is such that the police needs, to remove people from the area. And after 24 hours, the situation is diffused, so the persons would be left at liberty. In case more, the person needs to be kept in under arrest, then orders of the magistrate would be required, because that's a constitutional mandate also, that no person can be detained in custody for more than 24 hours without the order of magistrate. Another change that has been introduced is regarding witness protection scheme. Now, please see, witness protection, as we know that witnesses, they are the eyes and ears of law, and the entire case specifically depends upon them. The Supreme Court in the case of Mahindra Chawla versus Union of India had asked the NALSA that you draft a witness protection scheme, and they had drafted it. But there was no statutory mention of this witness protection scheme, that we need to protect the witnesses from the threats, intimidation, coercions that they received during the trial. So it is for the first time that witness protection scheme has been given statutory recognition in the form of section 398. Another is evidence of public servants, police officers in certain cases, section 336. Now basically this section, it allows that if some public servant is giving evidence, then he need not go to the court, and the evidence can be given through the means of audio, video, electronic means. So that is what the section talks about. Another major change that has been introduced in BNSS is regarding mercy petitions. Now please see, the president and the governor, they had the power to give mercy. They had this power under Constitution. They had this power under CRPC also. What was not there was, what is the procedure to file mercy petition? And if we see last few years, you'll see that sometimes there is a lot of delay in filing mercy petition, with the result being that because of delay in filing mercy petition, delay in deciding that petition, the convicted person, the court, the government, or the court in judicial review commutes the death sentence to life imprisonment. So there was no procedure that was given in our laws earlier, although there were some guidelines that were there on the ministry's website, but no statutory procedure. So this is a major change, where what will be the procedure to file mercy petition, who will file mercy petition, what is the time period for filing mercy petition, in how much time the central government is obligated to decide the mercy petition. This has been provided in BNSS. And one very interesting point as far as mercy petition is concerned is, till now, once the mercy petition was accepted or rejected by the president, the Supreme Court used to sit in review of that mercy petition. If you remember, even in the Nirbhaya gang rape case, the accused Mukesh Kumar, he was to be hanged. And a day before his hanging, on the day his hanging was to be executed, a day before that, he filed a judicial review in the Supreme Court saying that mercy petition has been wrongly rejected by the president. And if you remember, 2020, March 2020, the Supreme Court, during the late hours in the evening, they sat they said no, mercy petition was rightly rejected. And next day, Mukesh Kumar, an accused in the Nirbhaya gang rape case, he was hanged. So a change that has been brought in BNSS in section 472 is they have specifically barred that once the mercy petition has been decided by the president, then there cannot be any appeal. The courts cannot review the grounds on which mercy petition was accepted or rejected. So this is one major change that has been brought regarding mercy petition. And the last change that has been introduced, major change, is BNSS allows that all proceedings that are there in the criminal justice system that takes place, trial, inquiry, all proceedings, they can be held in electronic mode. So in this slide, I have specifically mentioned those sections. As I told you, some sections have been deleted. So sections relating to magistrate. Now, basically, if we see CRPC, it talked about assistant sessions judge, it talked about metropolitan magistrate. So these concepts, they have been removed from BNSS. They have tried to streamline the magistracy. They have removed the concept of metropolitan magistrate. They have removed the concept of assistant sessions judge. So all those sections which related to metropolitan magistrate and session judge, they have been deleted. There was a section related to juveniles that has been deleted in view of the Juvenile Justice Act that we have. Section 144, part to prohibit mass drills, has been deleted, and section 153 has been deleted. So these were some of the additions and deletions that has been made in the Bharatiya Nagrik Suraksha Sanhit. If we talk about change, as I told you, there have been around 177 changes, and there has been change in every chapter except chapter 8 of the CRPC. So now I'll just talk about what major changes have been made in other chapters. Concepts, I told you what 9 new sections have been introduced. Basically, what are the salient features of BNSS? What other changes have been introduced? One is use of forensics. Now, please see, even before today, the forensic science was used while investigating the crime. However, it was on the whims and vices of the investigating officer whether he wants to take the help of forensic expert or not. What has been mandated in Bharatiya Nagrik Suraksha Sanhit is that if an offense is punishable with more than 7 years of punishment, then the investing officer has to ask the forensic expert to visit the visit the crime scene and collect evidence. Please see, in CRPC, forensic science could be used, but that was not mandatory. Now, there were a number of judgments by the Supreme Court where they had said that the investigating officer, had he taken the help of forensic expert, there would have been better evidence in the case, especially if we talk about offenses like murder, offenses like rape. So, BNSS mein this change has been introduced that if the offense is punishable with more than 7 years of punishment, then you need to take the forensic advice in that very case. Although, keeping in mind that still there are some states where forensic labs are not developed, a time period of 5 years has been given to the state governments that within 5 years you have to notify this section. In these 5 years, you have to develop your forensic science labs. And if you are not able to develop, then you take the help of neighboring states. So one change is use of forensics, mandatory use of forensics in offenses punishable with more than 7 years of punishment. Second change that has been introduced in a number of sections is regarding electronic communication. As we know that today, the most common or prevalent mode of communication is through electronic communication. We communicate to each other through messages, WhatsApp, social media, or you can say portals. So this technology, use of electronic communication, it has been introduced in the Bharatiya Nagrik Suraksha Sanhit whenever there has to be a communication between two people. For example, when the court has to serve summons, earlier only the process server would go and deliver the summons physically, but now they have introduced a change which says that yes, summons can be served electronically. Second concept that has been mandated is registration of EFIR. EFIR, please see, it is not that EFIR was not getting registered before today. When the CCTNS system was introduced in India, there are 8 states in India which allowed the registration of FIR electronically. But all these 8 states also, they listed some offenses. For example, in case of motor vehicle theft, in case of some documents have got stolen, you could register the FIR electronically. But they did not allow electronic registration of FIR for all offenses. And some states may complaint could be filed electronically, which could be later on converted into FIR. But they had listed in categories may you can file FIR electronically. Now, what has been changed in Bharatiya Nagrik Suraksha Sanhita is they have not given any list that only in these cases FIR can be filed electronically, thereby meaning that for all cognizable offenses, if information is given to police officers electronically, then it amounts to EFIR. Though there are certain safeguards that once information is given electronically, the person, the informant, he needs to go and sign that information within 3 days in order to make that, in order to convert that into FIR when it is re-registered as FIR. Now, there are certain problems as far as the concept of EFIR is concerned. Basically, in September 2023, there was a report that was given by Law Commission of India which talked about registration of FIRs online, and they had said that for now, there need to be certain offenses for which FIR can be filed electronically. For example, in that report, they said offenses which are punishable up to 3 years, unke liye we can allow electronic filing of FIR, or cases in which the accused is not known, we can allow electronic filing of FIR. But when this BNSS came, they have not given any, they have not put any embargo, they have not laid any conditions, and they have allowed for any offense, electronic information can be given to officer in charge of police station. Now, there is another problem to this EFIR concept. Electronic communication can be through different means. Maybe if I drop a message, I drop WhatsApp to the officer in charge of police station, it will amount to FIR. So there are this will create logistic problems, that how to compile this information. So the government, the central government has been asked that you frame rules and you tell that what modes of electronic communication would be accepted. And for now, they have given certain, they have introduced SOP, they have uploaded SOP on Ministry of Home Affairs website. However, they have not listed that what modes of electronic communication are acceptable. So use of electronic communication has been allowed in Bharatiya Nagrik Suraksha Sanhita. Even charge sheet, when it is filed by the police, it is to be forwarded to the magistrate, it can be done through electronic means. So what I mean to say is, whenever a communication is to be made between two people, even if the victim is to be given certain information, so Bharatiya Nagrik Suraksha Sanhita allows that communication can be made electronically. Audio video recording, I already told you. Now, there are certain provisions in BNSS where they have mandated that audio video recording is to be done. For example, search and seizure proceedings. For example, when the forensic evidence is being collected by the forensic expert, rape victim is giving her statement to the police. There are these are the few instances where they have mandated that audio video recording has to be there. There are certain other proceedings where it's a discretion of the officer that whether he wants to record the proceedings or not. For example, when the statements are recorded by the magistrate during investigation, there it is optional whether the proceedings are audio video recorded or not. But yes, this feature has been added to the Bharatiya Nagrik Suraksha Sanhita, that in various places audio video recording has been allowed. Somewhere it is discretionary, somewhere it is mandatory. This feature was not there in CRPC. Another feature is about the timelines. Now, again, there are almost 40 sections where timelines have been added. That this particular procedure, for example, framing of charges, It has to be completed within this much time period. Discharge application, it can be filed within this much time period. Further investigation, it has to be completed within this much time period. Judgment, once the court has heard the arguments in the case and the evidence has been put at rest, case has been put and pressed, then what is the time period within which the judgment is to be given? What is the time period within which the judgment is to be uploaded? So there are a number of sections because they wanted to deal with the problem of delay. So timelines have been added in different places in BNSS where time limit has been given to the officers. Another point which is important is the law has been made citizen centric. Now, citizen centric means that provisions have been made specifically to make it accessible to citizens. How accessibility has been ensured, like I told you, the concept of EFIR has been introduced where electronically information can be given. Then concept of zero FIR. It has been given statutory recognition in BNSS. Zero FIR, if I talk about, zero FIR, the Supreme Court from 1994, it is saying that whenever some person comes to the police station and discloses commission of a cognizable offense, the police is bound to record FIR. But what is being seen is that many a times the informant is returned saying that this crime did not happen in our local jurisdiction. Even in the Nirbhaya gang rape case, there were reports saying that initially no police station was ready to register the FIR on the pretext कि पता नहीं कौन सी jurisdiction में crime हुआ है. So now there were guidelines by Ministry of Home Affairs, there were guidelines by the DGP office of different states that officer in charge of police station cannot refuse to register FIR on territorial plea, but still that was being followed throughout India. So BNSS has given statutory recognition. They have specifically mentioned in section 173 that when information is given regarding cognizable offense, then irrespective of jurisdiction, the police officer is obligated to register it. So that's how it is tried to be citizen-centric law. Victim-centric is another provision. Now, this is very important as far as victim-centric is concerned. One major change that has been introduced is one copy of FIR is to be given to the victim. And second major change is now victims many a times they do not come to know that what is happening in their case, especially when the case is at the stage of investigation. Because the police officers, they don't tell them what is happening in your case. So an obligation has been put on the police officer that within 90 days, you have to inform the victim that what progress in investigation is being made in your case. So victim-centric, the BNSS is victim-centric in the sense that right to know is being given to the victim. He gets a right to know about FIR, what is the content of FIR. He gets a right to know what investigation, how investigation is progressing in his case. And even when the case goes to the court, the magistrate, before initiating the case, he has to ensure that whatever evidence has been collected so far by the police, statements, documents, confessions, if any, recorded by the magistrate, all those things, all the copies of those statements and documents are provided to the victim. Earlier, we only ensured that these copies are there with the accused. Victim ke liye it was thought that because public prosecutor is there, so victim knows everything, whereas the reality was victim was feeling alienated. There was secondary victimization in our criminal justice system. So these changes have been introduced regarding the victim. And the last point I would like to discuss is regarding first time offenders. Now this is also a special feature of BNSS where special treatment is being given to first time offenders. CRPC never talked about first time offenders, although we had provisions in IPC which talked about enhanced punishment for certain offenses, but otherwise procedure mein aake first time offenders were never given a separate treatment. Although at the stage of sentencing, the courts did give a lenient view to first time offenders. Now, what changes has been introduced in BNSS is, as far as first time offenders are concerned, like I told you, in the offense of theft, if the person is first time offender, then instead of sending him to prison, if the value of property is less than 5,000, he is asked to undergo community service. So one, that provision. Second, in case of plea bargaining, in case the accused agrees to settle a case through plea bargaining, then less punishment is awarded to a first time offender. And thirdly, if we talk about under trial prisoners and the bail that is given to under trial prisoners, earlier under trial prisoners, they used to get statutory bail if they had already stayed in the jail for more than half of the period for which they were charged with. As far as first time offenders are concerned, they'll be released on statutory bail as under trials if they have stayed in jail for more than 1/3 period. So half ki jagah 1/3 ho gaya. And another change is now duty has been put on superintendent jail, that in case a person has been in jail for more than 1/3 period or half in case of other people under trials, then he has to file an application in the court asking the court to release those offenders, those under trials. So earlier we did not have any responsibility that was casted on jail superintendent, that you have to ensure their release. But now this duty has been casted on the jail superintendents, that you have to ensure their release in case they have suffered half or 1/3 in case of under trial prisoners in jail. So thank you. That was all I wanted to share with you.
Thank you, Dr. Shruti, for your nice and very precise presentation on BNS and BNSS. Before we proceed for another session, we will request we can have a 5 to 10 minutes interaction with Dr. Shruti. She has to go for some meeting. So anybody who have any queries regarding the BNS and BNSS, we can have an interaction with the speaker. If you have any questions, yeah, Maneet has raised the hand. Yes, Maneet.
Ma'am, can you please show the slides of BNS again? I wanted to note down certain points.
Yeah, sure, ma'am.
I think we can share it also later on if it's Dr. Shruti, if it's comfortable, you can share with me. I can share with the
Sure.
participants also. Yeah.
I think that
Because that would be better.
yeah, sure, ma'am.
Otherwise, Maneet, if you want to ask anything, you can please ask.
May I ask a question?
Yeah, sure, ma'am.
Good morning, everyone. I think it was a very good, very exhaustive presentation, Shruti.
Thank
you know, I have many questions, but I'm going to ask you only a few. Look, I feel that certain judgments, like you talk about, the judgment given by Justice Madan Lokur regarding the age, below 18 years, all that has been taken care of by the relevant laws, okay, IPC and CRPC. But there are certain judgments which are given much before, like we have very dynamic judgments regarding criminal jurisprudence given by Justice Krishna Iyer, Venkatachalya, Justice Bhagwati. Many of them have not been actually taken into consideration. For example, in Sunil Batra's case, Justice Krishna Iyer had said that an offender or a convict cannot have isolated living in the jail. Yeah, he cannot be put into isolation. But I believe that has been incorporated. Yes? Don't you think it is not fair?
Exactly, ma'am. What you are saying is right. In fact, because you mentioned Sunil Batra's judgment, even in that case, they mentioned about handcuffing.
Yeah, yes.
That was stopped. It was said that it is violative of Article 21. Whereas now they have put the provisions that yes, handcuffing is allowed in certain situations for certain crimes.
Yeah. So again, there is more, I feel, stringent and less recognition of maybe the personal liberty of a person.
Exactly.
You know, that's what I feel. And another point where you had made was that a new act has brought in electronic proceedings. Yeah. Here, I think in a criminal trial case, it is very important for the judge to also look at the body language of the person. And I feel a lot of manipulation can take place in such situations. So there are no guidelines, I believe, regarding this.
No, ma'am. Still, there are no guidelines, but what you pointed out is exactly true. Actually, they have brought the law, but now the time is when we need a lot of guidelines that how to
Yeah.
do this.
Right, 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 right.
Electronic communication, like I told you, even the means
Huh.
of electronic communication, they are not clear. So maybe if I'm a police officer, I have some number, someone sitting at XYZ place drops a message to me. That amounts
Yes,
to FIR. And
exactly. Yeah. Uh-huh.
it will be logistically very difficult how to compile that information, how to ensure that all
Mhm.
things are being looked. So we will be needing guidelines. Only then, there will be some
Yeah,
action.
guidelines, I think the courts will have to interpret to a great extent. And
Exactly.
with the two systems running together, whether, because we know that penal laws cannot be applied retrospectively, but when we talk about procedural law, that may be applied retrospectively. So there's going to be a lot of confusion and two parallel systems running together. And I think we are in for a lot of, I don't know, chaos or whatever for some time. For some time. And also regarding one more point which I wanted to make is that for drunken driving, I think the punishment is very little, isn't it? If you recall Nanda's case, he had actually run over 7 people, causing death of all 7 people, and he was drunk after a party. I mean, I don't think it's proper. Somewhere we really have to have seminars, workshops, and writings, to bring these aspects before the government and before the enforcement agencies. And also regarding the police, for example, we have that case which was a Lakshmi case, or which one? This was case about preliminary investigation.
Preliminary investigation. Yes,
Huh?
Nita
That
Kumar.
for all cognizable offenses, there should not be any preliminary investigation, except for certain categories like commercial transaction or things like that. But now there's going to be there's only going to be preliminary investigation, and they're not going to have FIR immediately.
Yeah. They have a
That
lot
is not
of
fair.
offenses. Yeah. So, yeah, punishable from 3 to 7 years. Yes.
Yeah. For example, if a woman is molested, a woman is raped, a woman, whatever, the different grades of rape which are now mentioned in the IPC, which are in the IPC, I think they've been retained. Then that means she cannot actually get a copy of FIR immediately. There'll be preliminary investigation.
Right.
Oh, on the one hand, they are bringing in victim-centering approach, okay, but on the other hand, they are taking away the power of access to justice for women who are victims of sexual offenses. You know,
Exactly. Yeah.
yeah.
I think there has been a lot of hurry. While
Yeah, yes, yes. And you know why I'm upset? One point that when the reforms committee was made, they did not take any woman as a member. That really hurts me. Really hurts me, And I feel that it was an opportunity for women to be, acknowledged and protected, but that opportunity was lost. Anyway, we'll have to read a lot, write a lot, and then give our own interpretation also. But excellent presentation, Shruti. Thank you so much.
thank you, ma'am.
Yeah, thank you, Professor Manjula. Thank you.
Yeah.
Any other questions?
Gurmeet, can I ask?
Yeah, Neerja, yes, please.
Yeah. Thank you so much, Dr. Shruti. It was really a very eye-opening session by you, and so many points were clarified. Only one I would like to say, maybe in the beginning I missed due to net problem. I think under section IPC 304, there is regarding medical negligence. So there is any change, and who is responsible? It is the particular doctor or the institution, and what is the process? Because in between the medical council was involved to do the inquiry, then it used to go to the court or whatever the procedure is. Can you just in 2 minutes can you clarify this?
Ma'am, see, medical negligence ke liye they have written that punishment only, imprisonment up to 2 years. Because otherwise, death by negligence, earlier it was imprisonment up to 2 years. Now they have bifurcated it into 3 parts. That medical negligence के cases में it can be imprisonment up to 2 years only. In other cases up to 5 years, and in hit and run cases, because it's death by negligence, up to 10 years. But that part won't be enforced from today, as I told you. Now, ma'am, regarding preliminary inquiry, like ma'am Batra also pointed out, in Lalita Kumari's judgment, the Supreme Court had said preliminary inquiry can be conducted before registration of FIR, specifically in medical negligence cases. So that is retained, because now they have given statutory recognition also to this point. Earlier, it was only a judgment of Supreme Court precedent, Lalita Kumari. So yes, medical negligence cases में preliminary inquiry can take place.
Okay.
Yeah, before registration of FIR. That is there, ma'am. They have not changed that procedure.
Okay. So the punishment is 2 years.
Up to 2 years, yes.
Up to 2 years.
Up to years.
Depending on the severity of that case.
Yeah, that is for the court's discretion, that how much they actually want to, sentence the accused to. But yes, imprisonment is up to 2 years.
Thank you so much for
Okay,
clarification.
welcome, ma'am. Welcome.
May I come in, ma'am?
Yeah.
Myself, Dr. Rajesh. I am Regional Director at IGNOU Center, Trivandrum. First and foremost, let me congratulate you for that wonderful session, ma'am.
Thank
It was
you.
really enlightening. I have a few queries which I would like to direct to you.
Yeah.
One is that these laws are going to be applicable to those cases which come up from this date, or which are already in motion at various stages.
Okay. Sir, like ma'am said, procedural law may changes can be there even retrospective. So whatever proceedings are going on in the court, procedure can change as far as those proceedings are concerned. जो offenses that were committed before today, ठीक है, उनके लिए FIR would be registered under IPC only, because BNS was not in force. So those which were committed before today, उनके लिए IPC का section लगेगा, but FIR would be registered under BNSS. अगर ऑफेंस पहले हुआ, FIR आज से हो रही है, तो IPC का सेक्शन लगेगा, बट रजिस्ट्रेशन ऑफ FIR वुड बी अंडर BNSS. जो आज के बाद ऑफेंस हुआ, दैट वुड बी BNS एंड BNSS, उसमें कोई प्रॉब्लम नहीं है. द थर्ड थिंग वुड बी जो केसेस ऑलरेडी देयर हैं कोर्ट में, उनमें बिकॉज नो वन हैज एनी वेस्टेड राइट इन प्रोसीजर, और प्रोसीजर जो है उसकी रेट्रोस्पेक्टिव ऑपरेशन हो सकता है, तो अगेन हो सकता है. नाउ इट इज फॉर द कोर्ट्स टू इंटरप्रेट कि कौन सा प्रोसीजर उनको अब से चेंज करना है, कौन सा नहीं करना है. जैसे जस्ट टू गिव यू एन एग्जांपल, FIR रजिस्टर हो चुकी है अंडर IPC, बट सर्च एंड सीजर की प्रोसीडिंग्स आज से हो रही हैं, तो वो रिकॉर्ड होनी चाहिए, हो सकती हैं, बट देन लेट अस सी हाउ द कोर्ट्स इंटरप्रेट कि अगर रिकॉर्डिंग नहीं होती, विल द क्रेडिबिलिटी बी रिड्यूस्ड. So that will have, so it's it's a situation of total confusion and chaos, like ma'am said, क्योंकि सब कुछ इकट्ठे चलेगा.
बिल्कुल मैम, बिल्कुल.
Yeah.
I have another small query as well, because in most of the major cases we have either the obiter dicta, which is very significant, or the ratio decidendi. So have these been taken care of in the new laws which have come in? Because laws have been changing over time. Anyway, if you have the IPC, CRPC, etc., there have been judgments right from the Privy Council days. So when the law changes as such, you have to incorporate all those, at least the major things. So how far has the new BNSS, etc., have been successful in incorporating?
So some judgments have been incorporated, like I told you, Navtej Singh Johal's judgment has been incorporated. Independent Thought versus Union of India, which talked about marital rape, it has been incorporated. But then there are certain judgments. If specifically I talk about the provisions of mercy petition, it is being said that what law was laid down by precedents, what we have enacted today is not in consonance with that. In fact, some points are contradictory, like handcuffing. Handcuffing may otherwise, the Supreme Court was of the view that it is violative of Article 21 and you need prior permission of the magistrate before handcuffing. Now they have specifically added section 43 subsection 7, where police officer has been given the power that, keeping in mind the nature and gravity, you can handcuff a person. And I'll just tell you that when these bills were tabled in August, they had also mentioned that handcuffing is allowed for economic offense also. it was only the parliamentary standing committee, because you see, economic offenses, most of them, are political people are allowed. So they said economic offenses may also you can handcuff. So I don't understand economic offenses may where would the person, run without handcuffing. Although that was taken care of, and parliamentary standing committee, they said delete this word economic offense at least, because it is too wide. But then they have written, they have put a section where handcuffing is allowed. So some precedents, they have been taken care of. Some, they have not been taken care of. Like I said, 498A ke liye, there were so many precedents. Preeti Kumari ka case, where the Supreme Court was saying, look into the law. It is being misused. Legal terrorism ka tool hai. That has not been looked into. And kai jagah pe it is gone contrary to what was laid down by the courts. So it's a mixture. We'll have to see from provision to provision.
Okay.
What about Vishakha, ma'am?
So Vishakha, sexual harassment as such तो at workplace as such तो नहीं है इसमें, but yes, sexual harassment के बारे में तो है, there is a section. At workplace specifically नहीं दिया, because that is we have the POSH Act.
Exactly.
Yeah.
Thank you, ma'am. Thank you.
Thank you. Thank you, Dr. Shruti. I think it's a wonderful presentation, and I think due to paucity of time, we have another session on Sakshya Dinam. So I think it's a very wonderful session. I think very knowledgeable. So I thank you, Shruti. I thank you very much. So we can have another session now. Thank you, Shruti ji.
Thank you, ma'am.
Yeah, I will request Dr. Anand, Faculty School of Law, to kindly introduce Dr. Zubair Ahmed Khan.
Thank
our
you.
next speaker.
I welcome Dr. Zubair Ahmed Khan. Welcome, sir. Dr. Khan is a faculty of law in the Guru Gobind Singh Indraprasth University. Currently, he is also the associate director of research and development cell, and he has a quite good number of publications to his credit. His specialization is criminal law, IPR, and business law. And I like the title of one of his projects which he has completed, procedure, law, procedure, and action. I like the word action regarding the bio-waste during pandemic period and thereafter. And currently he is involved in Currently, he is doing a project on the rights of farmers in the northern region, and it's a major research project which he is involved with, and he will talk about the Bharatiya Sakshya Adhiniyam. Evidence law is, we cannot call it strictly a criminal legislation. Evidence law is, proceedings in civil and criminal laws all are covered by evidence law. So law of evidence is same for civil and criminal proceedings. With this rider, I request Dr. Zubair Ahmed Khan to start his presentation.
Thank you, sir. Thank you, Dr. Anand Gupta. Thank you, Director Ma'am, for inviting me for the webinar on the reforms of 3 criminal laws.
No next heading. Untitled Google Chrome history.
Dr. Anand, can you switch off your...
Yeah, actually there's some issues.
Yeah.
History Google Chrome and Google.
Just a minute, yes.
History Google. History all items unselected. Selection mode.
Okay.
Is my PPT visible in nature?
Yes,
No, continue.
Yes,
Please
it's
continue.
visible.
Just
I think now it's gone. You can again share your presentation. Yeah, now it is visible. You can slide show.
ये सब चीजें मुझे पता है क्या करना होता है.
Just hold on, sir. Just
हाँ हो गया
Well, it's not muted, still it's going on.
Recurrent page 1. History Google. Chrome history. All items unselect. All items un.
Is my PPT visible? I'm not able to.
PPT is, yes, sir, PPT is visible, but you can make it slideshow.
Now is it?
Yeah.
Yes. Okay. A very good afternoon to all the delegates and the dignitaries present here. My topic is Bharatiya Sakshi Adhiniyam 2023, and since this and as I said by the previous speaker, that when there was a discussion or introducing these particular changes in the three criminal laws, the feedback of different legislative bodies, different can say national law universities, and different avenues has been taken forward also. And the way the Bharatiya Sakshi Adhiniyam has been changed altogether, it's been very clear that the aim and objectives of this act was to provide the evidence and to consolidate the principles of evidence for fair trial also. So in my overall presentation of this topic, I'm going to cover up all you the view holistic perspective of how the evidence, how the journey of evidence has been taken forward from Indian Evidence Act 1872 to BSA Act 2023. And in the BSA Act 2023, there are certain principles of evidence which has been still relevant today. And in the over the period of time, what more can be done under the for the effective implementation of BSA Act that needs to be explored, that needs to be contemplated further. So if you see my first slides itself, aims and objectives of the Bharatiya Sakshi Adhiniyam, it's clearly mean altogether that it is only for the purpose of fair trial. That is why the principles of evidence can be there. And fair trial is always based upon fair investigation also. Over the period of time, we have seen significant changes. Number of challenges came before the court of law, where the credibility of evidence, where the quality of evidence has always been certain has been put on challenge also. And it has been very clearly said that the evidence is to be tested through inherent consistency and its inherent possible probability also, and especially in those cases where we do not find direct evidence, where the cases are mostly based upon circumstances evidence also. So there was an era where there has been discussion, there have been debate between direct and circumstantial evidence. With the passage of time, when the IT Act was introduced, we have seen significant changes brought under the Indian Evidence Act 1872 to deal with the electronic evidence also. However, we have also seen that BSA Act have bring more changes now to see how this Bharatiya Sakshi Adhiniyam will be applicable also. So when you see the objective itself, it's been very clear that it is through electronic means how the evidence has to be taken care of also. So the idea was very clear altogether, whether it is a case of primary evidence, whether it is a case of secondary evidence, whether it's case of presumptions, the way the presumptions provisions chapter has been significant changes has been brought, or whether there have been certain other issues which has been taken care also. The objective of the Evidence Act was very clear altogether, that to bring the uniformity along in consonance with the BNSS and BNS as well also. So this is how the evidence has been taken care altogether. Now, when you see the evidence itself, it's very clear that this word has been derived from evidence also. And you see the Sakshas word is also something based upon the evidence quality also. How should we understand the evidence? It's something very important also. So over the period of time, the judiciary, the legislatures, the experts have made it very clear that these are the three principles based upon which the evidence has to be based also. The evidence must be confined to matter in issue. We have the relevant provision that is in the form of Section 3 BSA. Earlier, it was Section 5 of Indian Evidence Act also, which make it very clear that the evidence must be based upon particular facts in issue also. It should not be based upon irrelevant facts. It should not be based upon something which do not have any contact, any consonance with the facts of the case also. And that is why perhaps we always read about the relationship between factum probans and factum probandum also. Factum probans, which actually means the background of the case also. Factum probandum, which actually means the ultimate facts which needs to be proved also. And when we try to understand the nature of evidence from the ancient literature also, especially Narad Simriti also, it's been very clear altogether that it is the factum probandum which is the most important thing altogether. Second point is hearsay evidence must not be admitted also. Any kind of evidence which is based upon rumor, which is based upon third source, it must be discouraged also. That the idea is very clear altogether that it is not a kind of an evidence where you can put trust, where you can put credibility altogether, because the law of evidence has been very clear that we have to accept the credible piece of information also. Its independent verification is very important, apart from its pertinence also. The third one is the best evidence rule must be given in all the cases. We all know that India follows the adversarial justice release system in particular altogether. There's been discussion all there. And there they have been clearly mentioned that it is the quality of evidence which is more important than the quantity also. There have been very famous case which has been there, Ganesh Galve versus State of Maharashtra, which make it very clear that the nature of evidence is actually it's a kind of a function of a farmer who wanted to segregate the grain from the chaff also. In the same way, every in the court of law, every counsel, whether it is a plaintiff counsel, whether it is a defendant counsel, whether it is a prosecution counsel, whether it's a defense counsel, they will look for the qualitative evidence also. That is why we often talks about that the best evidence must be given in all these three cases also. So that's how these are the three basic elements of evidence which we often read over the period of time also. And even today, after the introduction of BSA Act 2023, they have become more significant in nature also, because the kind of challenge we're going to face in the near future with regard to electronic evidence in particular, these points has become very significant also. And as been said by the previous speaker, that how electronic communication and how electronic evidence or how digital records may become very important. And there have been a number of cases which we're going to discuss from 2003 to 2023 with regard to electronic evidence. It's been very clear altogether that this electronic evidence, or say any kind of evidence, they are very sensitive, they are very fragile also, and they are very susceptible to the tampering and to the any kind of action which may change the nature of the evidence altogether. That is why these 3 points, these 3 principles are very important altogether. Now, when it talks about the stages of evidence where the situation was remain in the before the BSA 2023, and even after under the BSA Act 2023, this same situation will be applicable. That is relevancy, admissibility, and appreciation of evidence. When it talks about relevancy in particular, also we always say that that it's the relevant fact. It's basically the legally relevant facts which are very important also, because you see the relevant facts are actually being classified into 2 categories: logically relevant fact and the legally relevant fact. And it is the legally relevant facts which are more considerable, which are more important also. And that has been true when you read the principle of res gestae also under the BSA, or when you read the principles how the evidence has to be appreciated in the case of conspiracy also. So it is the legally relevant fact where the proximity of the time, proximity of place, they become very important also. And it also been very clear altogether that these really relevant facts may be admitted before the court of law also. So again, that's how this next stage will come into picture, that is in the form of admissibility also. So when it talks about admissibility there also, we have certain provisions in BSA where we have been very clear altogether that these are the evidences which needs to be admitted before the court of law also. But again, whatever evidence is admitted before the court of law will not be accepted as it is in the same form also. There also the judge needs to appreciate the evidence also. So for appreciating the evidence, the same judgment which I have just quoted, Ganesh Galve's State of Maharashtra, will be applicable also. Because there it says the judge has to be convinced, yes, this is the nature of evidence which seems to be more convincing, which seems to be more persuasive in nature in proving the cases also. So throughout the journey of evidence in particular, when he talks about ascertaining the truth, when he talks about improving the particular truth altogether, these three things will be applicable also. We all know the relationship between evidence and proof in particular also, where evidence is actually the means and the proof is actually the result. And it is only possible when the nature of evidence passed through these three stages also. But at the same time, we have read that there are other judgments, there are other crucial points which may become very important. That is about the voluntary acceptance, the voluntary nature of the evidence also, whether it is the oral evidence, whether it's the documentary evidence. Its independent verification is also very important. And the third one is pertinence also. The pertinence nature is something very important also. So it's oral, documentary, or even if it talks about the electronic evidence or tape recorded conversation based evidence, these are the kind of principles are which are very significant in nature. And the interesting point is that with respect to the principle of evidence for the fair trial purpose, there have not been any significant changes in particular also. But there have been certain changes when it talks about how the point of the discussion has been there also. For example, how the word document has been defined altogether. So there is a significant change which has been brought, like electronic and digital records on emails and the laptop, smartphones, messages, the voice messages. They have been introduced altogether within the purview of documents. It's been very clear the kind of cases which we have come across in the IT Act altogether, maybe with regard to section 67, maybe with regard to 67A, B, and other sections also, where the definition of document is something very important also. Similarly, the document of evidence has also been made significant changes also. Now it has established the digital record as an evidence also. So again, that admissibility of evidence is something very important. Like in the BNSS also, where there have been significant changes with regard to section 94 of BNSS, which says about compelling the documentation in things. Now there's a change was brought where the electronic records can also be produced before the court of law also. In the same way, the evidence has been brought the change also, where we can record the evidence also of witnesses, accused, and experts through audio via electronic records. And also, the electronic records as an evidence can be accepted also. So this is another very significant, a very fundamental change brought under the BSA Act 2023 also. There is another point which was changed, brought, that is in the element of section 22 also. Section 22 BSA was actually the same kind of provisions which we have read in section 24 Indian Evidence Act, which says that the confession may become irrelevant if it is obtained through undue influence. If it is obtained through undue influence, it is obtained through promise or threat also. Now, a new word which has been introduced, that is in the form of coercion also. So that means any kind of coercive elements which has been brought through which the confession has been recorded, that also the evidence, the confession may become irrelevant in nature. There have been number of cases which came before the court of law over the period of time, which do not come within the purview of promise or which do not come within the purview of threat also. Though the very nature of the section 24 of Indian Evidence Act talks about impact of inducement is very important. Impact of inducement in the form of promise or in the form of threat is something very important. And there have been certain judgments which make it very clear that mere giving caution is not tantamounts to inducement also, but undue inducement also. But at the same time, there have been certain judgments which make it very clear about coercion also. So again, the court of law or even the experts have faced the challenges also. So I believe that this is one of the significant change brought under section 22, where the word coercion has been introduced also. That if by coercion, if you have taken the confession also, that will not be considered as a voluntary acceptance, voluntary acknowledgement, voluntary admittance of the confessional statement also. And that also proves the kind of cases which we have, Parvinder Kaur versus State of Punjab, and other cases where they have made it very clear about how the evidences, how the confessional statement must be accepted before the court of law. There have been other changes also brought under the BSA Act, where under the sector also we have the provision in the form of section 25, 26, and 27 Indian Evidence Act. Now they have been jumbled together, they have been clubbed together into one single sentence itself. But there, the provision has not been changed. Only the certain provisions has been deleted, but there is no substantial change brought under the provision of recording of confession. That has been very clear that the confession has to be recorded by a magistrate also. And there is a point which is also we have read in Indian Evidence Act with regard to section 27 of Indian Evidence Act, which says any fact which has been discovered has been mentioned, has been reiterated in the same way under the this provisions also. So again, in the chapter of this confession in particular also, this coercive element seems to be one of the important point which has been noted also. The next significant change brought under the BSA Act with regard to section 24 also, we have the provision that is where in the form of in Indian Evidence Act also, where the confession can be recorded by more than one person also. So it's been very clear that in the case of joint trial also, where this an explanation was mentioned, that in those cases, if under section 2484 you have asked if a proclamation has been issued, and if one person is absconder or is somehow absent in nature, even then the trial will be conducted as a joint trial also. Now, these are the challenges which we have faced in the past also. And there the law has been very clear altogether that if the multiple person is tried, if one person is missing altogether, the other, that still the law will be applicable in the same way. So section 24 has made it very clear that the fair trial or the speedy trial will not be compromised by any cost altogether. That is the reason why we saw a significant change under the provision of section 24 also, where an explanation was mentioned also. The next point which has been introduced with regard to section 39 of BSA Act. Section 39 of the BSA Act talks about experts. We have the provision of section 45 of Indian Evidence Act also. So section 39 of experts has been mentioned also about one particular point in any other field also. Though, if you remember, section 45 of Indian Evidence Act, it talks about an expert, which has been given, expert is a person who is an experience and knowledge in his own field also, and he be called before the court of law as an expert witness to a technical issue, technical fact, or technical issue which is involved. Now, there the point which has been clearly mentioned in section 45 that he can be called where based upon his experience dealing in the case of art, science, and other fields also, and the science and the forensic science in particular. Now, there the word which has been included about any other field also. So the lawmakers want to make it very clear, to make it more exhaustive altogether, that BSA can include, so under section 39 can include all kind of experts in depending upon the nature of field also. So in a way, this provision of section 39 has been expanded to make it to include each and every case wherever the point is not mentioned within the purview of art or science also. Next is section 52 of BSA Act also. Section 52 says the courts to take judicial notice of the laws, international treaties, agreements, other things also. There have been significant change with regard to section 52 because this is an old era law itself, where there have been certain provisions of the laws and the regulations passed in the British Parliament. So all those provisions has been removed altogether, and then this provision was introduced as it is in the contemporary situation also, where the court is going to take judicial notice of all the laws passed within the territory of India also. Section 57 is something very significant change was brought also. Section 57 is actually provision which deals with the primary evidence. If you remember, we have the provisions in the form of section 59 to section 63 deals with, in under Indian Evidence Act, deals with primary evidence and the secondary evidence also. Here, it starts from section 57 also. We're talking about primary evidence also. Now, in this section 57, there is an explanation which has been mentioned also about few things also. There are 4 pointers which has been mentioned. Number 1, that is about multiple files of the electronic records also. Each file is an electronic, is original in nature. The second significant change which is mentioned about the proper custody also. Any electronic and digital record is produced from the proper custody that it proves to be unless it is disputed. Now, of course, the word chain of custody is not explicitly used in Indian Evidence Act 1872, and not even it is used in the BSA Act 2023. But somehow it has become very relevant altogether, that how the evidence has to be procured also. So chain of custody is actually kind of a chronological sequence of gathering of the evidence also. How the evidence has to be gathered, how the evidence has to be maintained, how the evidence has to be examined, that needs to be taken care of. So throughout this process of chain of custody, the investigating officers and the experts in particular also have to ensure that there should not be any kind of tampering. There should not be any kind of action which vitiate or which compromise the very nature of fair trial purpose also. That is why they have made it very clear that in those particular situations also, the proper custody is something very important also. And in the same way, they have made it very clear, if the video recording is simultaneously stored in electronic forms or transmitted or broadcasted in thing also, each of the stored recording is original also. The similar point was raised in R.K. Malkani versus State of Maharashtra also. That was the first case where they have been, of course, there was an issue about tape recorded conversation, not about video recording in particular. But that was the point. It's been very clear about the few factors which are very important. Number one is the identification of the voice, whether it belongs to the concerned person. Second, it is about the concerned persons, whether the voice or the recording of this, the particular information or is relevant to the present case also or not. So these are the 2 pointers which are very, very important also. In those cases, this point has been something will come into picture when it has been transmitted or broadcast from one electronic form to another electronic form also. Again, the chances are high, the risk is very high. As I said, the digital records are very fragile in nature also. So and it's very important altogether that each crucial evidence must be stored altogether also. Even by a single click giving a wrong command also, inadvertently, you may lose the electronic records, you may lose the digital records also. That is why perhaps one of the main reason why they've made it very clear that each of the stored recordings is original in nature also. And that is why the same point which is mentioned, that each of the multiple finds of electronic coins is original in nature also. In the same way, there have been certain, due to the same conventional office space where maybe investigating officers have tried to access for the physical finds, will not be the same in the case of the information or the data available in the virtual space also. Because there can be certain data, there can be certain electronic or digital records which may be accessible also. But there can be certain electronic data records which may be there in the locked folders also, or which may not be, which may be there with which may be accessed through a particular password also. So that is why in those particular situations, these multiple storage spaces may become very important. Also. It is also important that all those temporary files, they become very original nature also. So the idea was very clear for the lawmakers through these changes, that they wanted to clear that this electronic evidence must be treated at par with the primary evidence also. Because the very idea of primary evidence, which we have read in Indian Evidence Act, is about that the original document itself also. Now, with this explanation, they have been very clear that no, each of these informations is something very crucial in nature. And apart from this section 57, it's been very clear that the scope of this secondary evidence has also been included, where it includes oral evidence, written admissions also, and other evidences where the person has been skilled in examining certain documents also. And there's a new provision which was introduced, that is in the form of section 61 also. 61 make it very clear that it brings parity in the admissibility of electronic and digital records and other things also, and it will have the same validity enforcement just like other evidence also. So this is the provision which actually upholds the value, the significant value of the electronic evidence also. This is the provision which have make it very clear for reminder of the cases which we have read from the M. Afzal versus State from 2003 to Arjun Pandit Rao, Kushal Rao case also, which discuss about the significant value or the evidentiary value of electronic evidence in particular also. So that is why we have saw a significant changes brought in section 62 and 63 of BSA also. 62 and 63 of BSA is particular those kind of provisions which we have read in Indian Evidence Act, that is in the form of section 65A and 65B of Indian Evidence Act also, which deals with how the electronic evidence, how the electronic has to be accepted also. So there the point has been very clear that it is important that whatever there are certain provisions which remains the same here also, that how the evidences has to be gathered also. So it's been very clear that it should be there from the communication device, it should be from the communication network, it should be communicating system in the standalone mode, or any computer resource enabling information or intimidity. Interestingly, the communication device is also defined in section 2HA of IT Act also, which make it very clear any kind of smartphone, any kind of personally digital assistance based software or hardware through which the information can be gathered, through which the data can be gathered also. And this is the reason why the communication device has been clearly mentioned also. And this is also the reason why they have used the word computer network also, because the way the kind of cyber crime are taking place, the way the kind of crimes which has been taking place at different times and different places altogether, this computer network may become very important also. Perhaps this is one of the reasons how the organized crime has been defined, and there we have to see that it is quite possible even at the virtual space also. That is why the communication, the network or the communication system in the standalone mode has been mentioned also. But there is one significant point which has been noted down in the section 62 and 63 of BSA with regard to admissibility of electronic evidence also. We have seen the changes brought all together in the past also, when for the first time in 2003 the state versus Muhammad Afzal was introduced. There it times is very clear that the electronic evidence can be treated as an evidence before the court of law. It can be proved before the court of law. With the passage of time, we have came to know about another judgment, that is Anwar versus P.K. Bashir also. That was one of the judgment which make it very clear that no, the certificate is something very important. So any certificate which recognizes, which give an authenticity to electronic evidence has become very significant in nature also. But over the period of time, we have also come across a case which puts a challenge, that is in the form of Shafi Muhammad versus State, because that case is something where the court of law have gone to such extent to give a relaxation also, that even if the certificate may not be available, still the electronic evidence can be accepted also. Now that created confusion altogether. But again, the matter was settled before the Arjun Pandit Rao versus Kailash Rao case also, where the Supreme Court have made it very clear that no, that the certificate issued in the case of admissibility of electronic evidence, it will be considered as a condition precedent to the admissibility of electronic record. So they make it very clear that the certificate compliance of section 65B of then Indian Evidence Act 1872 is important. Even today, the Arjun Pandit Rao case has become very significant in section 62 and 63 of BSA also. However, there have been the changes which is made altogether. There's one particular case which came very recently, state of Karnataka versus T. Nisar also. Now, this T. Nisar case is state of Karnataka versus T. Nisar is one of the particular case where the trial court have refused to accept the report given by the forensic body also. And there the prosecution have understood the electronic evidence as it is in the form of the primary evidence also. And it is found that the trial court has found altogether that there have been significant delay in issuing the certificate of the admissibility of electronic records also. That makes us worry, and the trial court have refused to accept the forensic report, and also the High Court upheld the same decision. But when the matter went approached to the Supreme Court, they have made it very clear altogether that this may not be right approach also. In any case, that if the non-acceptable, if the certificate has not been issued for the admissibility of electronic records, still it is a curable defect also. Still, the certificate has to be issued at any point of time also. So that case has made it very clear that the Arjun Pandit Rao case has been very important even today also. And in the light of these cases altogether, from state versus Muhammad Afzal from 2003 to this state of Karnataka versus Tinisar, this changes was burned altogether. Any submitting for certificate, you need to give an authenticity also. And how the authenticity can be given? It has to be signed by person in charge of the computer or the communication device also. So there in the BSA Act also, there have been there's a particular schedule in which a format is mentioned also. I have mentioned in my PPT, in which the person in charge of the communication device or the computer network itself has to authenticate altogether that yes, this is information which is relevant in nature and which is not be tempered altogether. So again, that certificate itself actually serves as an evidence support for the matter which it asserts also. So that is why this sections 57, section 62, and section 63 of BSA plays a very significant role altogether. And that is why these are the words which has been mentioned altogether, which makes the provision more relevant in nature, like communicable device, intermediary, computer network, and computer system in the standalone mode also. Now, the point which is important for us to contemplate that what should more be done to improve the BSA in terms of its effective implementation. So first thing which is very important, that every electronic and digital records must be properly secured and processed through the proper chain of custody also. Irrespective of the fact this provision may not be there altogether, but yes, the chain of custody is something very important for the recording of evidence itself also. So that is why they have made it very clear, either from procurement to the examination point of view, we have to see that the chain of custody has to be maintained also. Whether it is kind of DNA evidence, whether it is for the photography, whether it is kind of a audio recorded evidence, or whether it is kind of a video recorded conversation. Because concoction or any kind of minor alteration may be brought to the these kind of digital evidence also. And the court of law have made it very clear over the period of time in terms of the principle of evidence, that if there's a major discrepancy in the nature of evidence which changes the nature altogether, then the court is not going to appreciate also, because the credibility is something very important also. That is why make it very clear altogether that this protocol, this standard modus operandi has to be followed altogether, where a qualified forensic examiner must accompany the search team also. It is very important for different stakeholders to organize certain capacity building program where this kind of informations with regard to section 57, 62, and 63 of BSA must be followed altogether. And that is why they have made it very clear that we must prohibit the IO also from using seized electronic records during search and seizure of the electronic records also. So these are the informations which may become very important also. And there have been certain instructions which have been followed given by the Law Commission of India and few other judgments also about using a particular bag, that is Faraday bag itself also, which make it very clear to block the transmission in the electronic magnetic signals also. Again, that may be possible altogether to eradicate or to destruct the digital evidence in particular also. So especially if there are information which may be available in one single file, or maybe, for example, in the case of temporary file also. So that is why the seizing of the any electronic device is also become very important, whether it is a pen drive or whether it is a hard disk also. Another point which is more together, that we must use electronic evidence when it has been very clear altogether that it is a prima facie evidence and it has not been manipulated, it has not been forged also. So again, this must be the instruction altogether, because it is not the electronic evidence. We have the oral evidence and document evidence. We have the other category of evidence also through which the cases can be proved. But we have to make it very clear that this kind of practice must be followed. Any kind of substantial alteration in the electronic evidence in the form of manipulation, the form of forgery, must not be accepted before the court of law, because the court is going to appreciate those evidences also which are free from these kind of manipulations also. That is why these points has been something very important also. It is also important that the involvement of IT experts also wherever it is required at the request of accused also. So again, in those cases, these are the points which may become very important altogether, how the BSA needs to be followed and needs to be effectively implemented also. And it is very important for the enforcement agencies to organize different awareness programs with regard to encryption methods and other necessary infrastructures, which may become very important altogether, at the earliest altogether, because now today only it has come into force. So it is very crucial altogether that whatever challenges we are going to face altogether with regard to storage, with regard to the examination of electronic evidence, they become very important also. So these are the points which are something very crucial altogether to as to how to make BSA more effective in nature also. These are the schedule format altogether, how the electronic evidence has to be produced before the court of law, and it is something which has to be filled by the party also, that these are the information where you have to mention about the model number, the serial number, and these are the informations also which needs to be filled by expert also. Remember, the kind of changes which is brought in section 62 and 63 is also been done in consonance with section 79 of IT Act 2000 also, because there it's been very clear that is examiner of the electronic evidence also. In the same manner also, these are the informations has been clearly mentioned also. And again, which is also very important about the hushing procedure also, which is very crucial for the chain of custody. And the hushing procedure is also defined in section 3 subclause 2 of IT Act also. Perhaps this is one of the reasons where they have the lawmakers have made it very clear that this hushing procedure needs to be followed for the purpose of authenticity of electronic records in the case of IT Act, and that same has to be reiterated and replicated under the BSA also. So this is all about how the BSA Act has brought substantial change also. There have been other changes brought in terms, for example, in terms of section 138 of BSA Act, which deals with the accomplice also. And there they have been very clearly mentioned that that it should not become illegal when it is based upon uncorroborated testimony also. And likewise, there have been certain few changes brought in terms of the provisions of the cases, but the principles behind presumptions, rebuttable and irrebuttable presumption, may presume and shall presume and conclusive proof, and the principles behind burden of proof, reverse burden of proof, how it has been mentioned, the legal burden and the evidentiary burden have remained the same under the BSA Act 2023. That's how I have ended my presentation. If there is any question, any comment, any clarification,
yeah. Dr. Jubair, thank you for your nice presentation. I think it's you have briefly taken up all the issues regarding the admissibility of evidences which we will face, especially with respect to the electronic record. So I also want to raise certain points, but before if any questions, if anybody wants to ask any question.
May I come in, ma'am?
Yes.
Once again, this is Dr. Rajesh from Trivandrum. So thank you for that very interesting presentation. Many of the things which were unclear to people like me have been made clear from that presentation. But I would like to raise 3 points on which I would like your clarification. There is this section 112 in the Indian Evidence Act, which talks about DNA evidence as far as the paternity of a child is concerned when the parents are living together. Has there been any change to that in the new act, sir?
No, there are not been any significant change with regard to the DNA evidence in particular, because they have been very clear that it has to be accepted in the same form itself also. And we have number of cases with regard to the admissibility of DNA evidence, where it starts from Ramindra versus Sonam to other cases that make it very clear that DNA evidence is something where the evidentiary value is very strong also. And there have been cases like ND Tiwari versus Rohit Shekhar is one of the high-profile case, which proves the DNA paternity test also. So there they have been very clear that the DNA evidence cannot be considered, cannot be treated equivalent to the evidences, other scientific evidence, which may procure through lie detector tests and narco-analysis test also. Because here the DNA test is considered to be the most accurate information. Here it is usually considered as preponderance of probability. That means it is highly probable fact also. So usually we believe that the scientific evidence procured through DNA tests are actually something which is based upon inherent probability and the consistency also.
Thank you, sir. Another question that I have, you made a general observation that all the primary premises of Indian Evidence Act have been retained in the present act as well. But what about this major aspect of proved, disproved, and not proved. Do they also remain the same, especially in the light of the new additions in terms of information technology and all that?
When it talks about this definition clause itself also, there they have clearly mentioned that it is about may proved, disproved, and may proved also. When it was introduced in the 1872 law, Indian Evidence Act, there the idea was very clear altogether that it should be understood in terms of relationship between evidence and proof also, where we usually see the evidence is actually the means and the proof is actually the result also. So this is for the reason why these factors have been introduced. And when you see section 52 of BSA also, which make it very clear, the evidence can identify certain things as a judicial notice. So that is why we have the provision in the form of not proved also in the Evidence Act. So we do not see a particular change with regard to proved and disproved, even if there also. So the idea behind this proved or disproved under the Indian Evidence Act cannot be substantially changed over in the BSA Act also. So even if there is a deletion of certain provisions, there are certain significant principles which will remain the same also.
Okay, sir. The third thing and the last point that I would like to make is with regard to expert evidence. Now, so in certain cases, there have been a parallel which have been drawn between expert evidence and also supplementary evidence like that of sniffer dogs and all that. Do we have a retention of all that right now? Because much new technology has come in where we can easily discard this kind of sniffer dog evidence and all that. So do we kind of have a kind of change in this aspect in the new Evidence Act?
Before the introduction of BSA Act 2023, there have been certain cases where the court have accepted the evidence procured through dog tracking awards of the sniffing dogs also. So these kind of evidence are usually used for the purpose of identification of incriminated things. Incriminated things maybe the dead body, maybe the weapon, or maybe anything where the blood stain or anything is found also. So they become very relevant. So even if it is now included within the purview of any other field, it does not become merely irrelevant altogether. Still, they are very much applicable in nature also. Perhaps this is the reason we saw the expanded scope of Section 39 of BSA Act, where they have clearly mentioned about any other field also. So otherwise, they have been very clear that yes, the expert evidence in these cases may be accepted altogether.
Because I was asking this specific question because even in recent times, when the Indian Evidence Act was still in force, then also there has been several cases in which the court has said that you cannot rely on the sniffer dog evidence or the secondary evidence of this nature. It has become quite diluted in recent times. So that's why I was asking you this.
Expert evidence is it's just an opinion. That significant change is not brought with regard to the principle also. It's still an opinion. It cannot be binding also. But yes, it may be treated as an corroborative piece of evidence also, or it may be used for the purpose of contradiction by the opposite party person.
Thank you, sir. Thank you.
Yes, any other questions? Dr. Jabir, I just wanted to raise certain points here. I feel like Indian Evidence Act is focusing on more on admissibility of electronic records. But I think there are certain vulnerabilities which may come by how the electronic evidence may be admissible. One such thing is, for example, when the data is transferring through internet servers, so we can say unreliable links. So there could be chances when the data could be modified, could be changed. So there is a problem of data diddling. Not only data diddling, but many cases where, for example, in secondary evidences, where they are the Sakshi Adhinam is pointing out that a hash value can be matched and it can be used. But there are certain meta tags which provides for the information how the file is created, but what is the date of the file, who is the author, where it is, that can also be changed. So I think technologically, who is sound, the person who is committing crime and is sound in technology, they can change all those hash values also. The information in metadata can be changed. So I think that will also bring a problem in admissibility of evidence.
Yes.
And one more point I just wanted to, is whether the proper custody has been defined anywhere in this evidence. I don't think so. Yeah.
Ma'am, you have raised 2 points. Number one, that you have raised about how the complication or the intricacy with regard to admissibility of electronic evidence. That's true. For example, if hypothetically, if any information, any incriminating thing which may be found on the dark web also,
Yes,
or
yes.
any information through where the data or the digital data has been created by an unauthorized and anonymous person also. So the identity of it is very difficult for an expert to identify these things also. This is how we have also understood the use of AI also, where we have clearly mentioned nowadays we are discussing that now there is a conflict and there is a direct clash between cyber criminals and the experts also at the same time who are expertise in the cybercrime also. And in those cases, the unauthorized data cannot be can be identified also. And that's why there's a possibility not only of mere manipulation, but there's a possibility of data phishing also,
Yes.
or the data manipulation where the data itself has been created also. Nowadays deep fakes and other AI based bots has been introduced, so you never know the kind of new emerging category of cyber crimes which may come into near future. So it is very difficult for an expert to give an evidence and authenticate that this is an original document, even under the section 38 the subclause 2 of IT Act also. So this algorithm mapping is always a challenging task also. Perhaps this is one of the reasons that in terms of its implementation, that law enforcement agencies has to be aware about the encryption methods, has to be aware about how these hashing procedure needs to be understood and how it can be calculated within a short span of time also. So these are the points which are important. The second point which you've read about the proper custody. The proper custody has not been clearly mentioned under the explanation also, though it is mentioned under section 57 as an explanation. But again, ideally there is a desirability that this a proper custody should have mentioned. But what we mean that how the chain of custody which we used to discuss even before BSA also, because chain of custody is a kind of concept which many of the forensic science students or the experts or researchers are learning also. So they make it very clear that it is something where the proper chain of custody means that the data has been secured, has been properly managed in such a way that there is no tampering, there should not be any possibility of vitiating the nature of evidence also. So this is how we can understood about the proper custody, irrespective of the fact we do not have an explicit definition of proper custody within the Indian this BSA Act 2023.
But I feel like the term is used in section 57 that an electronic or a digital record is produced from proper custody. So I think we can also look into the provisions of IT Act somewhere here, and we can say that a person who is authorized or who is in custody of a computer or a computer system or a network can be deemed as a person who is
Can
a
be deemed as a,
custodian
yes,
of that computer or a
yes.
computer system.
That is why we
Yeah.
saw a significant change in consonance with section 79 of IT Act 2000 also, how the experts of electronic evidence has been introduced in the same way also.
Yeah, but I don't think so. There is any SOP is given for how the evidences would be collected electronically.
No, it has not been given. That's why I have given as a suggestion that these
Yeah.
are the evidences needs to be mentioned. However, there have been the reports given by the Law Commission of India, and there have been certain judgments which make it very clear that yes, these are the ways through which the electronic evidence has to be gathered all together in the presence of forensic expert or by using the Faraday bags, etc. Also.
Yeah. So, any other questions? Dear participants, if you have any questions on the subject, you can share your thoughts also. Okay. Okay. Then thank you, Dr. Jubeji, for a very nice presentation. And I think it's a very excellent and knowledgeable session. So now I may request Dr. Anand Gupta. Please present the vote of thanks.
Thank you. Today is a defining moment in the legal history of the country. And in one's life, we see such moments very rare. One or two moments at the most. People, there was a generation of people who have seen the constitution making, and there was a generation who saw 42nd, 44th Amendment, how the Constitution was, in a way,
reviewed or whatever was done with the constitution. Today, we are in a way going to overhaul the entire criminal justice system. So this is a defining moment. I how the things should have been done, whether the things could have been incorporated through amendments, there was a need for separate legislation or not. I think this debate has no meaning after today. Two or three things which I like very much about this legislation. Firstly, I will try not to repeat what others have said, our resource persons have said. Firstly, the Directorate of Prosecution. Now, there has been a debate for a long time to separate investigation from prosecution. And this thing has been taken care of by our new Bharatiya Nagrik Suraksha Sanghita. Another thing is with regard to complaint cases, 190 or the sections. Now, the court has to listen the accused or the other person also. This is a very important provision with regard to complaint cases, which I think is a landmark in the area. Another is with regard to sanction of public servants. Now there is a time limit, and within which, if the government does not provide, does not communicate anything, then it will be presumed that the sanction has been given. There are other points. Due to positive, I have different takes of many things which have been said so far. But let me come to my clerical work, which is very important. First of all, I would like to thank our resource persons, Dr. Shruti Goyal and Dr. Zubair Ahmed Khan, for their nice presentations. They have comprehensively covered the subject and cleared the doubts of our participants. I would also like to thank our Vice Chancellor, Professor Nageshwar Rao. Due to some engagements, he could not attend our webinar, but he was very supportive. I would also like to thank our Pro-Vice Chancellors, registrars, directors of schools, divisions, centers, units, and regional directors. And I especially thank Director COE, Professor Shachi Shah, for facilitating the availability of our webinar on YouTube. And I would also like to thank Mr. Rajesh Sharma, our CPRO, for making our webinar available on Facebook, IGNOU Facebook page. I also thank all the faculty members, academics, staff, research scholars who have spared time to be part of today's webinar. And also I thank people from my school, our director, my colleagues, our administrative staff who always work behind the scene, and without their contribution, any success of the program becomes very difficult. So I also acknowledge the contribution of our administrative staff. And I thank each and everyone who has directly or indirectly contributed to the success of this webinar. Thank you very much.
Thank you, Anandji. I would also like to convey my gratitude to everyone here. So I think we should give a applause and a heartful appreciation to our invited speakers and participants for taking their time to join this webinar and making this event a huge success. So thank you very much. Thank you to all.
Thank you, ma'am. Thank you so much.
Thank you.
Thank you, ma'am.
Thank you.
Thank you, sir. Thank you. Thank you.
Thank you.
Thank you so much.